Hello everyone. Good evening. Please confirm if you can hear me.
Yes, we can hear you.
Okay. It's already 6:30 is our starting time and I'd like to introduce myself. I'll be your moderator for today's session. So, welcome to the JIIPCC Julian Imam Intellectual Property Consult. My name is Ogonna Annette Onwudiewu, a 500 level law student from Nnamdi Azikiwe University and an IP enthusiast, at least for as long as I can remember. Today's topic is patent strategy, patent search, legal requirement for patentability. And this is the second week, week 2 of this mentorship and internship session. We have the most fascinating mentors for these programs. And today for week 2, we have Mr. Rakesh Sharma and Mrs. Amosa Shukurat. And I'll start with reading out their profile so you get to know them. Rakesh is having a thorough and multifaceted career spanning nearly a decade in patent analytics, drafting, and prosecution for US and EP jurisdictions. He worked very closely with various engineering teams and supported their portfolios from idea incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claim interpretation, and drafting skills. As a seasoned professional, he is readily engaged with various end-to-end IP services at different levels and provide intelligent IP solutions. He emphasizes more on promoting innovation for a better world. He loves drafting patent claims, keeping all the infringement perspectives in mind. Furthermore, he has a strong bent of mind towards IP automation and has sound knowledge of various IP tools and techniques that can be used for either improving quality of IP or increasing the overall productivity. He's also an excellent mentor and possesses all the leadership qualities required for a successful IP professional. If that doesn't awe you, I don't know what else. So we'll be meeting our second mentor for today, Mrs. Amosa Shukurat. Shukurat is a seasoned intellectual property consult, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious African University, Zimbabwe, in collaboration with WIPO and the Japan government. Shukurat is an alumni of the World Intellectual Property Organization, a member of the World Intellectual Property Organization International Network for IP Education, as well as a training facilitator at the Next Innovation Hub. She was a member of the planning committee for the WIPO National IP Essay Competition 2023 and resource person at the National Intellectual Property Conference, NIPC. Shukurat is an accredited agent at the intellectual property offices in Nigeria and a pioneer of the Tangible Nuggets, an educational platform which is responsible for fostering, among other things, intellectual property advocacy, awareness, and education. Wow, that's a lot, a lot. And I'm sure you're also as excited as I am to meet these mentors and digest what they have for us. So I'll be calling them up to introduce us to this topic, give us our first foray into what's our first insight into what the topic is all about. It's a Rakesh. Are you on call? Mr. Rakesh, I don't know if we have him here yet. Or anybody can go first. Mr. Musa. Seems like they're not on call yet. We may have to wait a while, just a short while. Okay, Mr. Musa is here, and we'll start with that. Good evening, ma'am. We just introduced you and the other mentor, and we're at the stage where the mentors give us our first foray into the topic we have for today. So you have the stage, a brief introduction into the topic.
Okay, so am I going first?
Yes, ma'am, you are.
Okay, allow me share my slide. Can you like shut up? Can you see my screen?
No. Yes, we can, ma'am.
You can, right?
Yes, we can.
Okay. Um, the topic for today is actually patent search and strategy, right? And the legal requirements for patentability. Am I right?
Yes, ma'am.
Okay. Hello, everyone. Good evening. So last week, we did introduction on patent drafting, and we spoke about what patent is, the requirement of patentability, where we have novelty, inventiveness, and industrial applicability. And we spoke extensively on what novelty is, what industrial applicability means, and what inventiveness means. So today we'll go in to talk about patent search, because before you file a patent application, the first thing you are required to do is to do a patent search, so you are able to know the prior act in the market or the prior act that's already available. And so you're able to probably develop on it, and you're able to build your own application. Because when you don't do a patent search, you might, at the end of the day, recreate what has been in existence before. And by so doing, you might not get your patent. So patent search is a process of searching and identifying existing patents related to an event idea. So when you are filing for a patent and acquiring a patent can be expensive, therefore, a patent search is a crucial part of figuring out whether any prior patent will interfere with your ability to acquire a patent. So how do you conduct a patent search? When conducting a patent search, the first thing you have to do, sorry. So when conducting a patent search, I would say patent search can be done in various ways and using different available online tools. However, the best way to carry out a patent search is number one, you kind of brainstorm keywords. Then you look at classes and subclass. Then you search patent and published application basis. So let's say, for example, you want to file a patent application on maybe writing material. Now, you don't just put in a broad term of writing material in the patent search database. You want to put in some important keywords that is related to what you are doing. So, for example, you might want to put in maybe ink, ball pen materials, just something that a keyword that you can actually set. Because if you just put in writing material, it's going to give you different patent application that has to do with writing material, and it might not be just basically on that ballpoint pen. So you need to brainstorm keywords. You need to look at classes and subclass, because find a patent application, we also have classes. Just like we have trademark classes, we also have classes in patents, which we call the Strasbourg Agreement for Strasbourg classification, if I'm right. Then we have searching patents and published patent application. So the next thing you want to do is, once you have identified how to actually do your search, then you want to look at where to conduct your patent search. How do you conduct the search? Where do you go to actually do your patent search? So patent and patent application published by many patent offices are available online, making it easier to conduct searches. So these patent search websites include, but it's not limited to what I have here. We have the USPTO, we have the Espacenet, we have Patent Scope, we have Google Patent, we have Patent Lens, and so on and so forth. So let me bring it home now. When it comes, you realize that we can't see anything Nigeria patent website here from USPTO. USPTO is for the US. Espacenet is for EU IPO. Patent Scope is the WIPO database. Google Patent is the general one. The Patent Lens, I think, is a privately owned website. However, in Nigeria, with our database, our search database is not available to the public. So you can't actually go and do a patent search yourself. So if you want to file a patent application in Nigeria, the first thing you have to do is you have to do a patent search. So you have to reach out to an IP expert or maybe an IP agent in the registry to do your patent search for you, because you can't do it yourself because the patent search database is not available in public. So unlike these ones, you can go to USPTO and carry out your search yourself. You can go to Espacenet and do yourself. But the thing is, if you are not in that line, you will be confused because you might not even know how to go about it. So it's always advisable to, get in touch with an expert to do your patent search for you. Because if you don't do your patent search well, and at the end of the day, you didn't find any application that might invalidate or anticipate your application, when an expert does a search, person is likely to come up with one or two things that is likely to anticipate your work, and they're able to, guide you and tell you what to do. Probably you work more on your patents, or you add one or two things just to make it different for what has been in the public domain before. Then types of patent search. Now, when you're doing patent search, you want to understand what type of patent search are you doing. Now, we have prior art or patentability search. If you want to file a patent application based on patentability, you want to do a patentability search to make sure that there is no prior act that is going to invalidate your patent application. That's the first thing you want to do, that if you're doing patentability search. Now, if you are doing invalidity search, in some instance, let's assume someone filed a patent application and the application has been granted, but you, the competitor, you want to try to invalidate that person's patent. You do an invalidity search just to make sure that, okay, maybe there's any work that can invalidate that person's application. Then another one you want to do is freedom to operate search. So if you are looking at where can I manufacture or exploit my patent right. You want to look at those countries whereby that patent application or where that patent is not covered. So let's say a patent is granted in the US. Now you want to look at other countries where a patent is not covered, where you can now probably exploit your patent other than where the application has been granted, because you can't exploit a patent where it has been granted without a license from the owner. Say, for example, when Massimo and Apple had their issue, Apple was infringing on Massimo's patent, right? So instead of them to do a kind of maybe freedom to operate search or get a license from Massimo, they failed to do that. So they were importing their Apple Watch into the US where Massimo has a patent, right? So doing that is infringement because Massimo has a patent in the US. So if they want to do like a freedom to operate search, they have to check other countries wherein Massimo doesn't have a patent, where the patent is not filed, a patent application is not filed in that environment. So let's say somewhere like Nigeria or somewhere like UK, where Massimo doesn't have that particular patent granted, then they'll be able to like export to that country. So if you look at the judgment, what the court said was that they are going to stop or ban Apple from importing to US because there's a patent in the US. However, this ban doesn't apply to importing to other part of the countries or other countries where Massimo doesn't have a patent. So freedom to operate says just to let you know where can I actually exploit my patent or exploit or sell my product. In fact, if you don't have a patent for it, where can I sell this product so that it won't be infringing on somebody else's patent? Then evidence of use search. You want to show that maybe somebody have gotten an application, a patent grant, and you want to prove that, oh, this person is not using it. You want to do like maybe an evidence of use search. Then state of the art search. You want to look at the kind of technology that is about the patent invention is about. So I think I'm going to stop here and let Rakesh carry on. Then I want to know, I want to ask Rakesh so you can speak on it. If maybe in Indian, I think it's practicing in the US anyway, but do Indian have a public database for patent search whereby Indian patent attorneys are able to search their own patent search other than the public one that are already available? So I'm going to stop here. Thank you.
Okay, thank you very much, Miss Shukurat. Um, I don't know. I don't think Mr. Rakesh is currently with us.
I thought I
Um,
saw him earlier when I joined.
yes, is autopilot. I don't know if
Oh,
he's present here. Yes. So Ma, I don't know. We still want to hear from you, and we would like to firstly apologize because I think our mentee sent a complaint recently that because of the network issue that it seems like it was not only within Nigeria, and a lot of our mentees are not based for patent drafting are not based in Nigeria, so they had issues putting together their presentation. I think it's currently ready at the moment, but the group presenter is having network issue currently and is unable to join the call. So, we kindly apologize for not being able to send the presentation as we supposed to. But if the presenter is able to join, we'll still have the presentation. Thank you very much, Ma.
okay, you're welcome. Yeah, I understand the network has been very bad. So do you say we wait for Rakesh or do we carry on?
Please, Ma, we can carry on, and then if Mr. Rakesh comes on board, then we can have his own part to it, Ma.
Okay. So probably I'm just going to um, Okay, can you see my screen?
Yes, ma'am, we can.
Okay. So let's quickly look at some examples. I want to show you an example of a patent form and a patent application. Okay. Okay, so let's continue. Let's look at structure of a patent application. So we've talked about patent search. Patent search is basically the kind of search you do just to check if maybe someone has to check what is in existence. So if I want to file a patent application for, let's say, a writing material, then you need to like go to the search database and check what has been on ground before. So you're not doing the same thing because, like we said, your invention has to be new. If it is not new, you won't get a patent for it. It has to be inventive. If it's not inventive, you won't get a patent for it. And it also has to be industrially applicable. If it's not industrially applicable, you won't get a patent for it. So let me take us through an example of a patent that is likely to infringe another patent. Then we'll understand what this is about. Okay. Okay. So let's look at this particular image. Can you see the screen with the one that has a chair? Can you see my screen? I'm not getting
Yes,
any response. Can you
we
see my
can.
screen
We can see your screen, ma.
with the
Yes,
chair?
Marie. I'm yet to see the chair.
Okay, you can't see the chair.
Not yet, but what we are seeing now is structure of a patent application.
Okay, no. Let me share this particular one. Okay, you should see it now. Let me know when you see it. Can you see it?
Yeah, yes, we can see your chair now.
Okay,
The
so
chair,
I'm going
ma'am,
to use
rather.
this. I'm going to use this to explain novelty. So like I said, patent search, you want to search if there's something similar in existence. So you are able to probably either stop that patent application or find a way to add one or two things to upgrade it. So look at this chair with the leather, with the brown leather, and we have this other one with sofa. So the one with the brown leather, if you look at it, it has a backrest, it has a seat, and it has 2 legs. Now, this other one with the ash color, it also has a backrest, it has a seat, and it has 2 legs. So let's address it first without the armrest and the seat support. So if this one, which is the brown one, is what we have in the prior act, and I am an inventor, I come up with this other one that also has backrest, seat, and 2 legs. This one will not be new because it has the same element as that in the prior act. Do you understand? Do you
Yes,
understand?
ma'am. Yes,
So
ma'am, we
if
do
my
actually.
patent application is on a material for seating, then I want to go and search. I won't just go and search on my patent database a material for seating. I want to search these key words: backrest, seat, 2 legs, or multiple legs. So it's going to bring me seating materials that has backrest, seat, and 2 legs. But if I just put in seating materials, it's going to give me numerous patent application that is for seating. So you want to streamline your application to make sure that you are looking at exactly what you want. So if peradventure, while I was searching the database, I come across this brown chair that has backrest, seat, and 2 legs, it means I won't be able to go ahead to find my own patent application that has the same backrest, seat, and 2 legs, because all the elements in my application also exist in the prior act. Now, let's now bring in this armrest and seat support. So if my own invention, this is my chair, has a backrest, has armrest, it has seat support, it has seats, and it has 2 legs. And what I found in the prior act only has backrest, seat, and 2 legs. It means what I have in the prior act will not invalidate my patent application because I have 2 extra elements, which are armrest and seat support, that are not in the prior act. Do you understand? So
Yes,
that
ma'am.
is the essence of doing a patent search. You want to search to see if truly there is nothing in the public domain that is likely to invalidate your patent search. Because imagine if you've researched, you come up with an invention, and you just file a patent application without actually carrying out a search. And along the line, your invention gets invalidated after you've spent money for registration, you've spent money to work on the invention and labor, time, and so on and so forth. Then you realize that at the end of the day, your application wasn't granted because it wasn't novel. So if you had done your patent search, your search result, you'd have realized that, okay, this my invention is actually in the public domain, and I won't get a patent application for this. So while you are trying to see what else can you do, probably that was when you can now start developing armrest and seat support, which is not in the prior act. So while doing this, you also have to make sure that your invention is inventive and is also industrially applicable. So like I said, you have different reasons why you want to do a search. It could be a patentability search, it could be freedom to operate search, it could be an invalidity search, different searches based on what exactly it is you are aiming at. So this is just to explain what novelty is when you are doing a patent search. So let's look at the structure of patent application. Okay. Okay. Let's look at this. So filing a patent application. So now that you understand what patent is, you understand the requirements for patentability, you also understand that it is advisable for you to carry out a patent search before you actually decide to file your patent application. Now you want to ask, what filing routes should you take? How do I file my patent application? And this is where the patent strategy comes in. So we have different strategy. We have different patent strategy. First off, we spoke about, okay, I think it was not in this class. It was the IP for inventors class, where we spoke about grace period. So in patents, some countries give you grace period even after you've disclosed your application. right? So you want to look at which strategy works best for my own business. Should I first of all file a pre-application? Once you file, then you can now file your main patent application 12 months after. So should you go through that route, or should you go through the grace period route, or should you go through the priority date route? So those are filing patent strategy. You want to look at which strategy works best for your business. However, you can't do this solely. You have to look at your business strategy and kind of implement it in your IP strategy, and you're able to decide, okay, this is what works best for my own business. So when you're now looking at where should I file? Where should I file to get my patent application? What you want to do is you want to look at the filing route. We have national filing route, we have regional filing route, and we also have international filing route. So when you are doing national, it means you are filing in your own country. And remember, we say intellectual property in general is territorial in nature. Whatever you do in Nigeria stays in Nigeria. So to make it easier, because if you want to file nationally, if I want to file my patent application in the US, I have to probably go to the US or get someone in the US to file for me. If I want to file in Ghana, I have to go to Ghana or get someone in Ghana to file for me. So anywhere I want to file in, I have to file there individually. And that is where the national route comes in. You have to file individually in those national or in those jurisdictions. Now, we now have regional route. Regional route is, for example, we have a kind of measure whereby a organization like JIIPCC. JIIPCC is the African Regional Intellectual Property Organization, and it has about 17 to 20 something countries, whereby when you file in JIIPCC, you can now designate other countries who are members of that JIIPCC. Unfortunately, Nigeria is not a member of JIIPCC. We also have OAPI. OAPI is OAPI, and it's for basically French-speaking countries. We have the EU IPO for European countries. So when you are filing regional routes, so let's assume I want to file application in 2 countries. Do you think I should go through the regional route, or should I just do national filing in those 2 jurisdictions? But if I want to file in about, let's say, 5 or 10 countries, the cost, that is what is going to cost me to file nationally in those 10 countries will be far more than what is going to cost me when I'm going through the regional route. So it's better for you to do a regional route when you are filing in much jurisdiction, because it also reduces the cost for you. Then internationally, under the international filing for patents, we now have the PCT, the Patent Cooperative Treaty, where you can file PCT and also, designate some other countries where you want that patent application to also be filed in. So those are the kind of routes you want to think of. Okay, should we do national? Should we do regional and international, depending on the scope of your business? The next thing we are going to look at is what are the checklists for patent application. So if you want to file a patent application, the first thing you need to know is the title of your invention. And like we said last week, your title must have a patentable subject matter. Your title should not be something like how to capture oxygen in the air. It has to be a patentable subject matter, that something that applies to what we have in our PDA. Like we said, there are some inventions that cannot be patented. Things that violate public morality, things that exist in nature, they can't be patented. So you must have a patentable subject matter as the title of your invention. You should also have your field of invention, like what field is this? So if you are working in probably the skincare sector, like your invention is about skincare, it could be, so this invention relates to the field of maybe chemistry and so on and so forth. Then the background of the invention, that's where you introduce the invention you are working on. You talk about what has been on ground before. You talk about the problem your invention is trying to solve and how you intend to solve the problem. Then you give a summary of your invention. You talk about the abstract. Just if I carry a patent application, from the abstract, I can say, okay, fine, this is what this is about. Then brief description of drawings. If you have drawings, you need to indicate the drawings as well. Then you now give a detailed description of the drawing. So let's say there's a way figure 1 or the 1 connect to 2 How does the head connect to the neck? How does it connect to the shoulder? How does it connect to the leg? You want to describe all of that. Then you give your drawings as well. So when it comes to drawings, you want to show every perspective or every angle of the drawing of the invention. You want to show the front view, the back view, the side view, the rear view, and so on and so forth. Then you have your claims as well. Then the next thing you talk about now is the same. This structure is the same like what we just said before. The structure of an application. So you want to, this request is like the form you are going to fill before you actually submit a patent application. Then you have your description, your claim, your drawing, your abstract. Then this is an example of a request form. I don't know if it's very clear. Can you see it at all? It's not so clear, right? This is an example of a request form just for you to fill. It's going to ask you the name of your invention, the name of the inventor, your address, and so on and so forth. So if maybe in future you want to commercialize this invention, or somebody wants to use your invention for something, they are able to, contact you. And if you come across, whenever you come across any patent application, any granted patent, you will see that all these informations, they are always there. I think I should have a sample. Okay, yes. This is a sample of a patent application. We have two samples. One is for Crocs, breathable shoes, and the other one is for your mouthpiece. So when you look at this, you see the country where it was granted, the filing date, the address, the name of the inventor, and so on and so forth. Everything about it, you're going to find in the patent document. Then this is an example of what a patent certificate look like. The one on your right-hand side is the certificate. Yeah.
Please, can you zoom it in for each sample so that the mentees can see it? We are barely seeing anything.
Yeah, it's can you see it now? I'm not sure it's going to come out well anyway, but you can always browse. I mean, you can always check it on Google. I found all this on Google, so it's not something that is hidden, okay?
All right, ma'am, thank you.
It's not something that is hidden. Once you just check online, you get them. So the one on the left-hand side is a NOTAP patent grant, and the one on the right-hand side, this is what the United States patent grant looks like. So I don't really have, okay, yes, so these two, then patent ownership, inventor, owner. So you have these, when it comes to employment, an employee and employer, in most cases, your employer owns your patent application, depending on what you sign during your employment. Then what rights do you have as a patent holder? You have the right to prevent others from making, using, offering for sale, or importing infringing products in the country where the patent was granted. You have 20 years monopoly from the date of filing of the patent application. You can either sell your patent, or you do a license and you get money for that. The patent infringement, basically you use somebody's patent without permission, then you'll be infringing on that person's patent. So what measures do you have to enforce your patent? Cease and desist notice, litigation, alternative resolution, administrative option. For example, we have a trademark tribunal. I'm not sure there's a patent tribunal, but it could be administrative option for enforcement. Then types of patent infringement, you have direct infringement and indirect infringement. All of these are not topics for today anyway. I'm just passing time in case Rakesh shows up. So yes, I think I'm just going to stop there, and probably we have the presenters present.
Okay, thank you so much, ma'am, for such an insightful session. I learned a lot myself, talking of the mentees. But then I'm not sure that I've been experiencing network glitches. I don't know if their presentation is ready yet. Mr. Dennis, are the presenters' presentation ready?
I don't think the mentee, the group presenter is currently here with us, but Please, if the mentee is currently here on call, have access to the presentation, please, we would like to hear from them, make them their presentation if they currently have it. Please, we would like to do that quickly. So please, if our mentee here on call have the presentation, please, we would like to take that. Thank you.
I think Rakesh is here.
Mr. Rakesh, I don't think so. It's just his autopilot, his AI. It's probably making a record of the conversation.
Probably should be here soon. I'm guessing he's just trying to break his fast because I'm just doing that myself because the timing is not so convenient for those of us that are fasting. So do we have anybody presenting or what do we do?
Okay, I think we'll just wait a bit to have Mr. Rakesh. And if he's unable to join in on the call, maybe in the next 10 minutes, and the presenters are not ready for the group, rather, is not ready for his presentation, then we'll just like to take questions so that we can have a more interactive session for the time being, depending if Mr. Rakesh can still join in, or we'll just be
Okay.
calling it an end to the session.
All right, that's fine.
So please, we sincerely apologize. Right, we'll be waiting for like the next 10 minutes to hear or to see if Mr. Rakesh will join in. Right, and if he's not, and our presenters are not ready, then we'll be taking questions. Thank you.
Okay, in the apps, it's about 7:20. We've waited for quite a while, almost 20 minutes, almost 10 minutes. So in the absence of Mr. Rakesh, I think we'll go on to the next thing on our agenda, which is the question and answer session. Mrs. Amosa Shukrat spoke for quite a while, and she made an introduction into the topic, gave us an insight into what patent search and applicability is all about. So, do any of us have any question on this topic? Patent search, patent strategy, or legal requirement for patentability. And well, it need not be on this topic. On patents, our mentor is a seasoned professional in this subject matter. So any question?
Shall I try to present? Can you hear me?
Nugus, can you hear us?
Yeah. Was the presenter in the backup presenter cannot come, so I think I'll try to present.
Sorry, we did not get your question. Please, can you come again?
What?
I think we're experiencing network glitches. It may be better if you type it so that our mentor would also understand the question. For any other person, you can type in your questions or you can just unmute your microphone and speak. Okay, there's a question in the chat box, and Mr. Amos, I don't know if you've seen it, but it's Nigus asked you, how can an idea be patented under strategies of patenting?
Okay, so your question is, how can an idea be patented under strategies of patenting? So I'll say an idea ordinarily cannot be patented, except when you express that idea probably in an inventive manner, and it is new, inventive, and has an industrial applicability. So the idea itself cannot be patented. Now, when it comes to strategy, the strategy is just a means of putting in place how you want to file your patent application or when you want to. So the strategy will not give you that patent grant. Okay, you still need to file a patent application the way you are going to file it. But the strategy is just, when should I patent it? How should I? In which country or in what country? Do you understand?
Yes, I do.
Okay, thank you so much, Mr. Musa. Do any other person have a question? Any other question? You can just unmute yourself or type it in the chat box. Okay, in the absence of any, ma'am, do you have any other thing? I mean, this is a wide subject matter. Do you have any other thing you wish to add or tell the mentees?
Actually, I would love to, but due to the network issues, so many people cannot join. I'll say probably we could start early next week so we can address this same topic and a topic for next week.
Yes, that makes sense. Okay, Nigos wants to present some slides. Mr. Dennis.
Okay, Eagles, please, if you have a presentation or if you're ready with your group presentation, I think we're still open to still hear from you guys on the work you could put together. So please, you can go ahead and present your slides. Like you can go ahead and share. Thank you. Can you hear us, Nigus?
Yes, I can. I'm trying to share my PowerPoint.
All right, thank you very much. Please go ahead and do that.
Can you see my screen?
Yes, we can.
Shall I begin?
Yes, go ahead.
Okay, so I have an idea about this, but I'll try to present from the slide. If you cannot listen to my voice, you can stop me anytime. So patent strategy and search, they are critical components on the patent strategy and search. They are critical components of the intellectual property landscape, particularly for individuals, companies, and organizations seeking to protect the
Is Nigus, are you still with us? Okay, I think Nigus has been logged out. Um, if Negus is unable to join in to continue with the presentation, I think we'll just be having the presentation Also, in the next session, we'll be having two presentations from our mentees from the previous topic so that we can also have further inputs from our mentors as regards the topic, and also as regards the topic for this week, and also from tomorrow next week's topic. So please, Nigos, if you're unable to join in, I think we'll be calling it a wrap for today's session. And we want to thank Miss Amosa for joining in. Sorry, I've been interrupting the moderator for today. I just had to stand in as a backup because of some of the issues that we are currently experiencing. Um, Okay, we'll be reviewing this this our time that we are currently meeting 6:30. I don't know if it's convenient for, especially for our other members who are currently on their fast, because I know this is going to be colliding with their time for breaking. So I don't know if it's going to interrupt with it. So we may be reviewing the time. Any further information about that will be passed down to our mentees and also to our mentors. So thank you very much for joining in for today's call. Please, our moderator, please, you can go ahead and end the session for today.
Everyone that made out time to join us for this session. Oh yes, we will have our picture time before we conclude. So I will tell all of us to please turn on your videos. Let's see your face and take a screenshot. Tell everyone, preach the message of JIIPCC. Tell everyone about JIIPCC. Share what you learned on social media platforms, and appreciate the mentors too. So please turn on your videos. I apologize, there is no light where I am. It's picture time. Please turn on your videos.
Please, can we have more mentees turn on their video if that will be possible? Yes, thank you, please.
Okay, please take screenshots and repost on your social media platforms. Share what you learned. Tell more people about JIIPCC. Okay. Thank you so much for that. And we'll finally draw the curtain at our today's session. We are, due to the network challenges, we hope to perhaps have a repeat or at least a summary of today's class at our next week class. And yes, so we'll draw the session to an end. Thank you so much for making our time to attend. Thank you for being there, regardless of your time constraints. We also appreciate our mentor, Mrs. Amosa Shukurat. I don't know if I'm pronouncing it right, but thank you for making our time and for always, ever since I knew you, you've always been a consistent mentor at JIIPCC. So thank you, yes, for making our time for this. Thank you to the mentees for listening, and let's see again next week.